This guy's garage. Like and subscribe.
Speaker, I'm rising on the notice of a question of privilege that provided the table with following the tabling of the 17th report from the Standing Committee on Government Operations. At the outset, I want to note that the Government Operations Committee is actually meeting this afternoon, so our colleagues who sit on the committee may well wish to address this with the House tomorrow or possibly Friday. But last week, Kristian Firth, the co-founder of GC Strategies, a two-person IT firm that does no actual work, finally appeared before the Government Operations Committee to answer for his and his company's role at the heart of the Liberal government's Arrive scam. The House is well familiar already with the Auditor General's damning report of this procurement fiasco. Other investigations have been popping up left, right and centre by other officers of Parliament, including possibly the Royal Canadian Mounted Police. I believe that the Globe and Mail's Bill Curry pegged it at 12 active investigations. Parliamentarians had questions for Mr. Firth and his partner Darren Anthony, who had long resisted appearing before committee. That's why the committee, in its 14th report, had asked for a House order to compel their appearances before the committee, backstopped by the authorization of a Speaker's warrant to take them into custody if necessary, and the House had unanimously concurred in that report the same day that it was tabled. As I said, Mr. Firth appeared to answer questions, but answers would not be how I describe what he gave. That's why, at the conclusion of his appearance last Wednesday, the Government Operations Committee unanimously and without debate adopted a Conservative motion to present a report to the House, quote, outlining the potential breach of privilege concerning Kristian Firth's refusal to answer those questions, which the committee agreed to put to him, and his prevarication in answering others, end quote. The area of greatest concern that I want to highlight was Mr. Firth's refusal to say which public office holders he communicated with concerning the crafting of a so-called competitive contract with the Canada Border Services Agency. The House will recall that the Auditor General found at paragraph 1.56 of her ArriveCan audit that GC Strategies was involved in developing the requirements set out in the agency's request for proposal. Naturally, parliamentarians wanted to know who spoke with him. Mr. Firth, however, stonewalled several members, including me, with repeated refusals to answer those questions directed to him, citing an RCMP investigation. When he was pressed on whether he understood the imperative nature of answering questions at committee, he again refused to answer, citing solicitor-client privilege. On other occasions, Speaker, in response to other questions asked of him, the witness offered evasive responses, a concept referred to in some procedural texts as prevaricating, something which I will elaborate upon in a few moments. I would draw your attention to a handful of exchanges in committee with Mr. Firth as examples. I asked whether Mr. Firth had lied to a parliamentary committee before. Mr. Firth answered, quote, watch my previous testimony, end quote. I also asked which public office holders Mr. Firth had met outside of government offices. Mr. Firth answered, quote, I'm more than happy to provide that information in writing, but I'm not prepared to do that right now, televised, end quote. The honourable member for Sherwood Park, Fort Saskatchewan asked Mr. Firth how many hours he spent sending LinkedIn invitations, a key component of GC Strategies' apparent recruitment strategy, and Mr. Firth answered, quote, that has no bearing on this project, does it? End quote. The honourable member for Carlton Trail Eagle Creek asked Mr. Firth to name his contacts in the various departments which provided GC Strategies with 134 contracts. Mr. Firth answered, quote, I'd like to provide all of those details after the meeting, please. I would not like to speak about it publicly, just with how this committee is going, end quote. I asked Mr. Firth to name the individuals who allegedly provided the glowing testimonials which appear on GC Strategies' website. Mr. Firth answered, quote, I do know the answer. I will provide it after this meeting, end quote. As an aside, Speaker, I believe that the committee is still waiting on Mr. Firth to make good on some of those undertakings which he had promised the committee he would answer by 9 a.m. the following morning. The Government Operations Committee might have more to report on that in due course. I'll also add that there are concerns about the truthfulness of some of the testimony from Mr. Firth and other witnesses throughout the course of this committee study. However, that may well be a matter for yet another future report from the committee. For today's purposes, we are, of course, concerned with Mr. Firth's refusal to answer questions and his evasiveness on others. Your predecessor, Speaker, ruled on May 11, 2021 at page 7021 of the debates about the role of committees in questioning questions of privilege concerning witnesses' evidence. Quote, there is no precedent where the chair has used there is no precedent where the chair has used testimony from a committee without there being a report on the subject. This aspect of the matter is a concern for the chair. It is not for the speaker to untangle the committee evidence to determine who knew what and when. Such an initiative would trespass on the role of committee members and constitute a breach of my duty to act with impartiality. It is up to the committee to continue its own study and to inform the House of its conclusion if it deems it appropriate, as has been the tradition, end quote. Speaker, the Government Operations Committee has done its work. It has informed the House of its conclusion that Mr. Firth obstructed it through his refusal to answer questions and providing prevaricating responses. Now, House of Commons Procedure and Practice, 3rd edition, page 82, borrowing from a list of established contempts laid out in a 1999 report of the United Kingdom Parliament's Joint Committee on Parliamentary Privilege, enumerates established areas of contempt, including, quote, without reasonable excuse refusing to answer a question or provide information, end quote, and, quote, engaging in other misconduct in the presence of the House or a committee, end quote. On August 12, 1947, the United Kingdom House of Commons resolved, quote, that the refusal of a witness before a select committee to answer any questions which may be put to him is a contempt of the House and an infraction of the undoubted right of this House to conduct any inquiry which may be necessary in the public interest, end quote. Parliamentary Privilege in Canada, 2nd edition, explains at page 191, a committee is not restricted in the scope of its questions. It can pose a witness, and a witness must answer all questions put to him, subject only to a point of order by a member of the committee that the question should not be permitted, and with an ultimate appeal of the chairman's ruling to that committee, end quote. Beauchene's Parliamentary Rules and Forms, 6th edition, adds at citation 863, quote, a witness who is unwilling to answer a question after stating the reason for desiring to be excused from answering may appeal to the chair whether in the circumstances for the reason stated an answer should be given, end quote. If you consult the transcript of last Wednesday's meeting of the Government Operations Committee, Speaker, you will see several instances where the chair was asked, without any objection from the committee, to direct Mr. Firth on behalf of the committee to answer the questions. Certainly, no members objected to the questions that were asked. The chair, having heard the reasons offered by Mr. Firth, nonetheless directed him to respond. The chair also reminded the witness about the protections offered to him by the law of parliamentary privilege. Perhaps it would be also helpful for the House to be refreshed on those important principles. Beauchene's notes at citation 109, quote, witnesses before committees share the same privilege of freedom of speech as members. Nothing said before a committee or at the bar of the House may be used in a court of law. Thus, a witness may not refuse to answer on the grounds of self-incrimination, end quote. Bosque and Gagnon add at footnote 681 on page 1080, quote, as with members, freedom of speech is extended to the testimony given by witnesses before committees and has been held to include protection from any possible prosecution, end quote. The reasons behind this important principle are elaborated upon by Bosque and Gagnon, page 93. Quote, this right, freedom of speech, is also extended to individuals who appear before the House or its committees in order to encourage truthful and complete disclosures without fear of reprisal or other adverse actions as a result of the testimony. In 2005, the Federal Court of Appeal ruled in Galliano v. Canada, Attorney General, that the testimony of a parliamentary witness fell within the scope of parliamentary privilege because it is necessary for the functioning of Parliament for three reasons: to encourage witnesses to speak openly before the parliamentary committee, to allow the committee to exercise its investigative function, and, in a more secondary way, to avoid contradictory findings of fact. End quote. In 2007, the federal court again recognized in George v. Canada, Attorney General, that a witness's testimony before a House committee is protected by parliamentary privilege. Although a witness before a parliamentary committee are not members of Parliament, they are not strangers to the House either. Rather, they are guests who are afforded parliamentary privilege because, as with members, the privilege to ensure that they are able to speak openly, free from fear that their words will be used against them in subsequent proceedings. The court confirms that parliamentary privilege, quote, precludes other entities from holding members of Parliament or witnesses before committees liable for statements made in the discharge of their functions in the House, end quote. Mr. Firth, however, persisted in his refusals, citing the RCMP investigation and solicitor-client privilege. Given the latter grounds, it's perhaps important to refer back to Beauchesne's citation 863, Speaker. Quote, a witness is, however, bound to answer all questions which the committee sees fit to put and cannot be excused, for example, on the grounds that there could be a risk of a civil action, or because the matter was privileged communication such as that between a solicitor and a client, or on the grounds of advice from counsel that the question cannot be answered without risking self-incrimination or a civil suit, or that it would prejudice a defense in pending litigation, some of which would be sufficient grounds of excuse in a court of law, end quote. Very similar words appear at page 38.36 of Erskine May 25th edition. The fact remains, Mr. Speaker, that Mr. Firth was asked questions, he refused, he was pressed to answer by the committee, and yet he continued to refuse. That is, I respectfully submit, a contempt of Parliament. Next, Mr. Speaker, I want to turn to the matter of Mr. Firth's prevaricating evidence. The Canadian Oxford Dictionary, second edition, defines the verb to prevaricate as, quote, speak or act evasively or misleadingly, end quote. Derek Lee's The Power of Parliamentary Houses to Send for Persons, Papers, and Records at page 180 states, quote, witnesses have been guilty of contempt by the House or similarly punished by the House for prevarication, end quote. Erskine May puts it at paragraph 15.5 of the 25th edition as follows, quote, in the past, witnesses who have prevaricated, given false evidence, willfully suppressed the truth, or persistently misled a committee have been considered guilty of contempt. That entry, I would add, falls under the heading of, quote, misconduct in presence of either House or a committee, end quote. A phrase found in the list of established contempts found on page 82 of Boskin Gagnon. Now, parliamentary practice in New Zealand, 4th edition, also comments in relation to witnesses' obligation to tell the truth. At page 7776, quote, even to prevaricate before a committee might invite questions, end quote. Now, in the United Kingdom House of Commons, several committee witnesses in the 19th century faced the wrath of the House when giving prevaricating evidence with a finding of contempt, even committal into the custody of the Sergeant-at-Arms or at Her Majesty's Jail of Newgate. Example cases may be found, I won't read them all, but at page 601 of the Journal for August 28, 1835, at page 258 of the Journal for February 24, 1848, at page 147 of the Journal for April 7, 1851, at page 699 and 742 of the Journal for July 20th and 29th, 1853, at page 354 of the Journal for July 28th, 1857, and at page 239 of the Journal for April 23rd, 1866. a close cousin of prevarication is the willful suppression of the truth. On March 3rd, 1828, a committee of the whole of the United Kingdom House of Commons, considering the East Retford Disenfranchisement Bill, had before it a witness, Jonathan Fox, who spent 90 minutes answering most questions with some variation of, quote, "I cannot say." The witness was asked to withdraw while the committee deliberated. These deliberations at column 936 of the parliamentary debates are insightful. For a quote, Mr. Alderman Waithman observed that the committee could not suffer its dignity to be trifled with in this way. He would appeal to the committee whether this man's answers could be believed. Something ought to be done to support the dignity of the House, which ought not to be trifled with in this manner. He should move that the witness has been guilty of gross prevarication. Mr. Baring asked how, if the inquisitorial power of the House was to be exercised, that power could ever be exercised if it was treated in this manner. One phrase was perpetually in this man's mouth. Here was a man who had entertained the committee for an hour and a half with the same answer. He had been guilty, in his opinion, of gross prevarication. Mr. Peel thought it doubtful whether the witness had been guilty of prevarication. It seemed a willful suppression of the truth. The Attorney General agreed that the conduct of the witness did not amount to gross prevarication, although it was evidently a willful suppression of the truth. Mr. Wynne confessed that he did not know what prevarication was if the witness had not been guilty of it, end quote. Now, in the end, Speaker, the House adopted a resolution that Mr. Fox, quote, has attempted to defeat the investigation of the committee by willfully suppressing the truth, end quote. All of that is to say, Speaker, that Mr. Firth was quite clearly dodging and weaving in his evidence to the committee, desperate to avoid giving answers. He was, to borrow from the Canadian Oxford Dictionary definition, answering evasively. Now, based on the authorities which I have cited, that is a further contempt of Parliament committed by Mr. Firth. Normally, Speaker, this is the point where I would say I'm prepared to move the appropriate motion. But what is the appropriate motion? Bosque and Gagnon comment at page 150 that, quote, the terms of a privileged motion have generally provided that the matter be referred to a committee for study, end quote. Footnote 386 hastens to add, quote, there have been exceptions to this practice, end quote. So what would be the objective of another committee study in these circumstances, Speaker? The facts are crystal clear. The question and the refusals are already on the record. Would we ask the Procedure and House Affairs Committee to report back saying, yep, Kristian Firth definitely refused to answer those questions, and man, he was really cagey too. Mangot at page 263, I believe, offers the answer. And it is, quote, nevertheless, open in flagrant cases of contemptuous conduct to move that the facts in question constitute a breach of privilege, end quote. He wrote a little earlier on the same page, quote, the practice at one time provided that the alleged contemner be brought to the bar of the House, end quote. Indeed, that is what the House decided to do in June of 2021 after the government defied an order of the House concerning the production of Winnipeg lab documents, summoning the President of the Public Health Agency of Canada to appear at the bar to receive an admonishment on behalf of his agency. Now, these circumstances are a little different when we're dealing with a committee witness providing testimony rather than a document production order aimed at the government. The House has, since the turn of the century, held two witnesses in contempt for their evidence before committee. In 2003, the Government Operations Committee concluded that the former Privacy Commissioner, George Radwanski, had deliberately misled the committee in his testimony and should be found in contempt of the House. However, given that Mr. Radwanski had apologized to the House in writing, in addition to having resigned as an officer of Parliament, no sanctions were applied beyond the contempt finding. In 2008, the Standing Committee on Public Accounts determined that RCMP Deputy Commissioner Barbara George had knowingly misled the committee in her testimony before the committee and recommended that she be found in contempt of the House, but ordered no further action on the recommendation of the committee, quote, as the finding of contempt is, in and of itself, a very serious sanction. Now, more recently, in 2011, the Standing Committee on Foreign Affairs and International Development's sixth report provided the House with extracts of evidence given by the Minister of International Cooperation, which contradicted her statements in the House. Now, Speaker Milliken ruled on March 9, 2011, that there was a prima facie case of privilege, and the matter was referred to the Standing Committee on Procedure and House Affairs, which heard from the Minister and other witnesses, but it did not complete a report before the Parliament was dissolved. Now, those cases involved contradicting answers. We were concerned here with getting answers. Therefore, we must look back further in time for instances when the House addressed similar situations. Now, in June of 1891, one Michael Connolly, a witness before the Privileges and Elections Committee, which was investigating allegations of corrupt practices on the part of a member of the House, refused to turn over documents which he brought with him and was being asked about. Now, this was reported to the House, which in turn ordered him to appear at the bar, where he was questioned, granted counsel, and ordered to turn over the documents in question. In August of 1891, Thomas McGreevy, the member whose corruption was being investigated by the Privileges and Elections Committee, appeared as a witness and refused to answer questions. The matter was reported to the House, which ordered him to appear in his place in the House to answer those questions. Mr. McGreevy did not appear, leading the House to order him to be taken into custody. Despite the Sergeant-at-Arms' pursuit of Mr. McGreevy by train as far as Quebec City, he was not captured, but was expelled as an MP the following month. In 1906, William Preston, a civil servant, appeared as a witness before the Agriculture and Public Accounts Committee, where he refused to answer questions. Each committee reported the situation to the House, where a motion to summon him to the bar was debated, but a Liberal government amendment, which excused Mr. Preston, was adopted instead. Now, in 1913, R.C. Miller, a witness before the Public Accounts Committee, refused to answer questions. The matter was reported to the House, which ordered him to appear before the bar, where Mr. Miller was further questioned but persisted in refusals of his answers. The House, in turn, found him in contempt, sent him to prison, where he remained until Parliament was prorogued 4 months later. So, let's be clear. I'm not proposing that Mr. Firth be imprisoned for this particular offense. We must all recall that this House is possessed with awesome power and authority to vindicate its role as the grand inquest of the nation. Citations 123 to 125 of Beauchesne's elaborates, quote, "Privilege grants considerable punitive powers to the House of Commons. The mildest form of punishment is a simple declaration that an act or an article is a breach of privilege. When an individual has been present at the bar, it has been customary to deliver this conclusion to the culprit in the presence of the House. On such occasions, censure of the individual is usually added to the conclusion that privilege has been offended. Occasionally, the individual at the bar will be given the opportunity to purge the contempt and promise better conduct in the future. For more serious contempts, the House may proceed further," end quote. Now, before anyone worries that this might be an intense approach, the United Kingdom's Parliament Joint Committee of Parliamentary Privilege in 1999 reported at paragraph 301 and 302, compellingly explained the need for such powers when confronted by contempts. Quote, "The first question to be considered is whether contempt of Parliament by non-members should still attract any punishment at all. We believe it should. Take as an example the investigatory work of committees. Powers must exist to ensure that committee investigations can proceed, that witnesses will attend, and that papers will be produced. Apart from public officials and ministers, many interest groups and representative bodies and many companies and private individuals also appear regularly before select committees of both houses. They almost always appear voluntarily. However, occasionally, witnesses are unwilling to appear or information necessary to an inquiry is not willingly provided. If the work of Parliament is to proceed Without improper interference, there must ultimately be some sanction available against those who offend. Those who interrupt the proceedings or destroy evidence or seek to intimidate members or witnesses, those who disobey orders of the House or a committee to attend and answer questions or produce documents. Sometimes the conduct is a criminal offense. Then the criminal law should take its course. In the case of non-members, that will normally suffice. But unless a residual power to punish exists, the obligation not to obstruct will be little more than a pious aspiration. The absence of a sanction will be cynically exploited by some persons from time to time. Now, some from the Liberal benches might urge upon the chair in the House the fact that these powers concerning these witnesses had not been used in many decades, and therefore they might argue that they're now in doubt. They might even, Speaker, object to me referencing precedent longer than their time in this House. And to that, I would answer with paragraphs 76 and 77 of the 2013 report of the United Kingdom Parliament's Joint Committee on Parliamentary Privilege, which formed part of an analysis on options for enforcing the House's authority. Barely 10 years old. Quote, "It is unfortunate that Parliament's restraint has led to doubt about the continuing existence of its powers. They are a part of United Kingdom law and have been so for centuries." In this section, we would consider the third option, which would involve the two houses reasserting their historic penal jurisdiction and setting up procedures for exercising that jurisdiction. The first and most important challenge is to assert the continuing existence of each house's jurisdiction over contempt. This is fundamentally a test of institutional confidence. We urge the two houses to rise to this challenge, end quote. So this is why, Speaker, my, quote, appropriate motion would rise to the challenge, and it would do the following. It would find Kristian Firth to be in contempt. It would order him to the bar of the House to be admonished by the Speaker. While at the bar, he would be required to answer the questions which the committee struggled to obtain answers to, as noted in the 17th report table today. And finally, there would be provision for supplementary questions to Mr. Firth arising from the answers that he provided. The first three items are perfectly consistent with and are modeled upon the order of the House adopted on June 17th, 2021, where the President of the Public Health Agency of Canada was summoned to the bar to receive an admonishment and turn over the documents which had previously not been provided. Indeed, Lee writes at page 241, quote, "Where the House finds that a breach of privilege or contempt has been committed by a person, the House may take steps to coerce the offender into complying with the order of the House or committee that resulted in the breach of privilege or contempt," end quote. Given the distinction here of seeking answers to oral questions as opposed to the production of papers, I would propose allowing for supplementary questions to be asked. Now, while it has been some time since a witness has been questioned at the bar, the sequence of events would, I respectfully submit, be consistent with the past precedents that I cited of witnesses who had refused to answer questions at committee. Now, though the relevant forms and procedures are old and do not neatly fit into our contemporary way of conducting House business, it does not make the idea impossible. Now, Sir John Bournois' Parliamentary Procedure and Practice in Dominion of Canada, 4th edition, at pages 70 and 74 explains the procedures for questioning witnesses at the bar for those who want to understand the area better. In conclusion, Speaker, the 17th report of the Government Operations Committee outlines a troubling new development in the Liberal government's Arrive scam, which I believe amounts to a contempt of this House. Parliament deserves answers about this fiasco. All Canadians deserve to know those answers. We cannot allow the House of Commons to be trifled with or cynically exploited by witnesses who are too clever just by half. We must rise to the challenge. We need to demonstrate our institutional confidence as the grand inquest of the nation. We must get answers from Kristian Firth about his conduct that is at the very heart of the Arrive scam. If you agree with me, Speaker, once we have allowed an opportunity for colleagues from the Government Operations Committee to speak to the matter, if they wish, I am prepared to move the motion which I outlined earlier. Thank you very much.
I sincerely thank the member from Leeds, Grenville, Thousand Islands and Rideau Lakes for its intervention. The intervention of the member from Leeds, Grenville, Thousand Islands and Rideau Lakes, I will hope that the members of our Government Operations Committee will quickly intervene, as well as we'll hear from the members from the Bloc and from the NDP, as well as from the Liberals, who indicated that they would like to come back on this issue. But I guess I'm sort of tipping my hat. I'm quite disposed to this motion. So I look forward to an intervention as soon as possible so that we can dispense with this matter quickly.